Good afternoon, everyone. Thank you for having given me an opportunity to speak to you this afternoon. But I should start off with an apology. I hope to have done this by Skype, but I've been called away for something fairly important and had to do this by video instead. So please forgive me for that, because I would have been happier to interact with you there at the conference, and a conference which I think is extremely important. The I.S.A, simply put, is a draconian law. I don't think there's any other way to describe it. We know it most of all for it allowing the minister, and through the minister, the government of the day, to subjectively determine at will individuals ostensibly for being threats against the national security without any chance of judicial review. I say without any chance of judicial review because although the Act itself does allow for a limited form of review on matters of procedure, and at common law we've been made to understand that these sorts of detentions can be reviewed where the minister acts in bad faith or mala fide. In Malaysia over the years, the federal court has virtually tied our hands to an extent where it is only where the minister has failed to file the necessary form or fill in the necessary document required under the law that challenges are allowed. Even where ministers have been shown to have acted in bad faith, the courts have said no, we will not intervene because this is a matter for the executive. Now, in part, I think this may be because over the years the independence of the judiciary has eroded to an extent that for all purposes and intents it's nothing more than an extension of the executive. And I think that's given some light by a decision of the federal court recently, in which the federal court, a five-man panel by majority of 4, said that the doctrine of separation of powers has no place in this country. So what that means, in essence, by virtue of the Internal Security Act, a law that was actually designed for a very different purpose and a very different time, the Minister of the Home Affairs, or Minister of Home Affairs, or Minister of Interior here, is given the subjective power to determine those individuals that he, I can put simply, doesn't want to see free. Now, over time, we've seen, those of us who have been actively involved in these areas as either lawyers or as activists, we've seen instances of these powers being used for purposes which, on their face are very odd. At about the same time as Raja Petra being detained in 2008, September, a young journalist with a Chinese newspaper was also detained. And because there was such an outrage expressed over the detention of a journalist, the government had to reconsider its position, and ultimately, when pushed to offer an explanation, the government said that they had detained the journalist for her own safety. Now, if that is an acceptable basis for detention, then one wonders what isn't. And over the years, we've heard many instances. In one of the more favorite myths surrounding the law, we've heard of it being invoked against persons who are spreading rumors of vampirism. So, there's no other way to describe this act, really. And when understanding its impact and application in Malaysia today, we see the extent to which it undermines democracy. Because those of us who would be quite prepared to be arrested for various offences because we believed in what we did, in forms of civil disobedience or otherwise, mainly because we would be given a day in court and the trial that guarantees, would be very hesitant to do anything which would possibly cause the spotlight of I.S.A scrutiny to be shone on us. And that has had an incredibly stifling effect on civil society in this country. The cornerstone of any modern democracy must be the right to life and liberty. It must be. It must be guaranteed that an individual citizen is not put in jail at the whim or caprice of the leaders. Only then can we say that we are in a functioning, effective democracy, because where leadership is allowed to put people into detention for reasons which it thinks best, one often hears, and the experience we've had here is consistent with that, of detentions being perpetrated or orchestrated in order to stifle dissent. Now, the freedom of life and liberty is articulated primarily through the right to a fair trial. But under the I.S.A, detainees are not given that fair trial. What they have instead is an arbitrary detention, a subjective detention at the behest of the minister, and then an illusory form of check and balance through the form of what we call the advisory board hearings, which happened within about 3 months of a detention in Kamunting. Now, we must not confuse detentions by the police, which the police are allowed to do under the I.S.A. for periods of up to 60 days, and the ministerial detention. While in 2001 we managed to convince the federal court that that first stage of detention by the police was one that could objectively be reviewed by the courts, meaning the courts could ask to see evidence of the alleged threats to national security and why these individuals were considered to be such. The ministerial detention, which allows for 2-year detention periods in Kamunting, allows for no such scrutiny according to our courts. So what we have is a situation where a minister decides to put someone in, and I'm going to come to the case of Rajapetra in a minute, and then when that person says, look, I should not be in this place, I am not the threat that you say I am, he's expected to say that to an advisory board that's more or less concerned with merely the technicalities of the detention, and not seriously interested in most cases that I've understood, not seriously interested in the merits of the decision of the minister. So the reality is, therefore, there's nothing more than a procedural safeguard insofar as the procedures of detention are concerned. It is draconian because of that, it completely denies the right to fair trial, and that is where we are. So so in coming to the case of Rajapetra, I remember it was sometime in, I think, September of 2008. I get a phone call from Haris Ibrahim, and he says they're at Rajapetra's house. Now, this is something that we've been expecting for some time. Petra had obviously been extremely vocal. They've been very active in the run-up to the elections of 2008, and had played a pivotal role in mobilizing civil society. He had been actively crusading, as it were. And so when that phone call came, I must say that I wasn't surprised, but nonetheless, it sent a chill down my spine, because one never wants to hear of I.S.A. detentions taking place, especially in the context of a political struggle. And it also possibly heralded to many of us the advent of a time of repression that was far more marked than what we had become accustomed to. And I think, the Operasi Lalang in 87, many people remember that, but as they grew older, and as the memories faded a little bit, the chilling effect of that experience somehow became either dampened or faded or completely forgotten. And of course, you had younger people who had never experienced that time of 87. So when that phone call came, Haris says they're at Petra's house, and I said, what do you want me to do? And he says, could you just go over there right now and make sure that they're complying with procedure and making sure everything's okay, and make sure that Marina is okay, and so on. I said, well, does Petra want me to act for him as counsel? And he said, of course we want you to act as counsel. And I said, well, I don't think I should be going, because I don't want to be involved as a witness, ultimately. So Haris said, never mind, he'd go there, and Haris told me he'd be in my office in about an hour or so. And this is at about 2 o'clock. 3 o'clock came and went, 4 o'clock came and went. There was no sign of Haris, and I began to get a sense that maybe this was a little bigger than we expected it, or we had thought it might be. And when he walked in at 6 o'clock, I saw from the expression of his face that, yeah, it was much more serious, and that we were looking at an operasi which was wider than Rajapetra. The first thing I asked him as he came in was, are you on the list? And he said, I am. And I said, do you know whether I'm on that list? And he said, not sure, it doesn't seem to be, but you may be as well. And so you think about what to do in a time like that. You're never actually really prepared for something like that. And I started getting phone calls from other people saying that maybe I'm on that list, maybe I'm not. And they were warning me, they were warning Haris, and at the same time we had to deal with this habeas corpus that we had to file, because that was obviously what we had to do. So we decided to just push on and began to prepare the papers. And over the next few days, after a very harrowing night, uncertain of what was going to happen, Teresa Kok got picked up, and the journalist got picked up before that. We were wondering when the next one would happen, and the one after that. I had a word with Zaid Ibrahim, was then Minister of Law, and he expressed great concern. He was wondering whether he could do anything, and he was also wondering whether it was time for him to take a stand, and so on. So all of these tumultuous things were happening. But the next morning we got up and we were still out and about, and that night was put aside, and we carried on with what we had to do, which was to prepare the habeas corpus. Now, from the very beginning, it was clear that this was not going to be an easy run for us, mainly because we had to convince a High Court judge who we couldn't be sure was not going to be hostile to us, or at least sympathetic, that there was a way in which he could navigate through binding precedent of the federal court to actually give us judicial review and habeas corpus. We had to do this in a context where he would be telling us that there would be no right to review under the law. So we thought about it, we worked very hard, I won't go into the technicalities and the legalities of it, but we came up with a solution, and we took it to court. I mean, there were some stages in between, and there were some hiccups, but finally we got to this hearing in October. Rajapetra had been in for some time now, I think almost a month by this stage, and obviously there was a lot of pressure on us because we're friends with him and friends with the family, and all of us were very concerned, and Petra was not wanting to eat, he was on a hunger strike, and all these things that were happening, and against the wider tableau of events as well. But as I said, we endeavored, we focused, and we went to court. And I must say we were lucky to have this judge. He was compassionate, he was fair. His name is Helmi, he's now sitting in the Court of Appeal. And from the moment go, it was very clear that he was open to being shown a way as long as we could convince him that he could do it in law. And we took him through it. And we showed him how that the law was actually passed to deal with the communist insurgency, how there were necessary preconditions to the exercise of the power, how the minister had to be shown that there were events happening around him that this person that he wanted to detain was so involved in that they were one and the same, and that if he allowed this person to carry on conducting himself in the way he did, there would be essentially a chaos or chaotic situation. We managed to show him that was the law. We managed to show him how he could get to that conclusion by reference to case law from this country as well as from the UK. And then we showed him how Rajapetra was certainly not that. Yeah, so it was quite funny because I started to read the articles that Rajapetra had written. There were 3 that the minister had said was so dangerous that they required him to be put away for 2 years at the minimum. I read the judge one of these articles, and obviously Rajapetra in his usual style had written it very, very wittily and very, very sarcastically. So the gallery was in stitches because here was Rajapetra's words alive in a courtroom, and the judge was getting quite uncomfortable and saying, really, do you have to read this? And I said, well, if you think this is a threat to national security, and you look at the kind of reasons that the minister has given for the detention, it's quite clear that the only thing he hasn't thrown in is the kitchen sink. And the judge laughed. And he saw that at that point, I think, I'd like to think that there are certain limits to this sort of thing. And the reality is, you had someone who was saying very legitimately that he was unhappy with the way that things were going politically. He was unhappy with the way the government was conducting itself. And then I asked the judge, how different is this from a conversation in a coffee shop between three friends of many years standing, sitting down over a cup of tea and saying, really, don't you think the Prime Minister is such an idiot? And I say, if by calling the Prime Minister an idiot, I'm a threat to national security, then I think most of us in Malaysia would be in detention. And so the judge laughed. And I think the point was made there that, in as much as we see there may be legitimate reasons to have anti-terrorism laws and so on, the I.S.A. is simply not the answer. We need greater check and balance. We need ways in which the government can be monitored in the way it does this. And the best way to do that is by allowing comprehensive judicial review. The judge saw the point that day, and I'm glad to say that he gave us a win. Although that came about 2 or 3 weeks later, and that in itself was a indescribable moment. All my friends were there, people in the cause, as it were, and they were openly weeping. Harris was openly weeping in court as the judge proclaimed that he would be releasing Rajapetra, and Petra was ordered to be brought to court later that afternoon, 3 o'clock, and huge following there. And of course, we were concerned about the rearrests and expecting it, but it never happened, and Petra went on from there to the various things he did. As a postscript, I could say that the government did appeal it, and that led to an extremely contentious set of hearings in the federal court. One hearing in which we accused the 3 judges to have acted in abusive process and contempt of the court as well as in bias. But things became academic because Rajapetra then decided that it would be best for him, for his own reasons, not to be in the country. So when we put all of that together against the context of the law, and we look at the experience of Rajapetra, and of course, as exciting and as humorous as it may have been, or it may have seemed, the reality was far different. It was extremely painful for his family. It was extremely painful for his friends. It was extremely nerve-wracking for his lawyers. And I think looking back, as much as I'd like to say that was a landmark victory, I'm hesitant to say that because The reality of it is the confluence of events and circumstances have brought us to that particular point. Whether that will set precedents, I can't say. The government appealed it, but due to technicalities and Rajapetra not being here, this appeal was struck off. So for the moment, the High Court decision stands. But whether it's going to become foundation for a federal court decision, which will then in turn set a new direction for the law, I'm not hopeful. The statute works too much to advantage at the moment politically for anyone any incumbent to actually want to give it up. So I think the only way we're going to be able to be rid of this law or to escape its draconian effect is to have it completely repealed. And I'm hoping that that the next election, one of the primary themes of the election is the repeal of the I.S.A. because there is simply no place for it anymore in this country. If we're going to move forward as a democracy, if we're going to progress, if we're going to be able to say the things that need to be said, we need to be mature enough to be able to say them. With laws like this and the other laws that impact on our democratic rights to free expression and assembly and so on and so forth, we're going to keep ourselves so stifled and so inexperienced in dealing with these sorts of difficult issues that we will forever and ever be a society that's incapable of addressing its reality. Now that's something that I don't think is correct. I think we're mature enough as a society to move on. We're mature enough to be engaging on critical themes without May 13 coming up in every conversation or every newspaper publication or anything of that sort. And I'm hoping that this conference and conferences like it will start creating awareness of what we need and how we need to get to where we have to get to. Thank you.